And when you cascade votes, probably the one who has come to court was the one who got the least votes. And the Supreme Court then says the people who are going to participate are only the petitioner and the president-elect. It would be just unreasonable. It would be awkward. So I would say if somebody has come and explained himself why he did not petition, what his takes are, what he considers to be his rights, and considering that it is a question of democracy and representation, I would take the view that an interested party who has made that expression.
Thank you for this rather long engagement. I wish you the best.
Thank you very much, Mike.
Thank you. A long day so far.
It's okay. It's okay.
Yeah, they say Kenyans know the Supreme Court to be the court that only deals with presidential petitions. So I understand why Judge Murima had to take a lot of that time. So, Judge, you did submit submissions that you have handled at the Supreme Court and High Court on matters touching land, criminal case, arbitral award, and a constitutional petition appeal, and also shared a no case to answer motion filed before the International Criminal Court. The exhibit excellent issue identification, coupled with strong ability to link facts to applicable legal principles. And looking at the ICC matter, where you submitted on the need for clarification on application of the no case to answer principle within the ICC framework vis-a-vis common law jurisdiction, I find the arguments novel, so I commend you. Have you since delivered any decision at the Court of Appeal or decisions?
Yes, I have.
Okay. I know my colleague will ask you around that. So allow me to ask you two questions.
Yes.
Of elections, because the Supreme Court does so many other things beside the elections which Kenyans are usually keen on. Key strength in arbitration is finality, and that is why you find most laws on arbitration clearly provide for this fundamental principle. In the new to aggravate case, the Supreme Court was confronted with what is described as question of considerable public importance touching on the interface between arbitration and the appellate jurisdiction of the superior courts in Kenya. So what the court held is that Section 35 of the Arbitration Act is silent on whether an appeal should lie to the Court of Appeal, and this is what it held in part. Allow me to read. An appeal may be allowed in very limited circumstances where a manifestly strong decision was made. Specifically, where the High Court, in setting aside an arbitral award, has stepped outside the grounds set out in Section 35 of the Act and thereby made a decision so grave, so manifestly wrong, and which has completely closed the door of justice to either of the parties. So how would you describe the reasoning of the court by creating this exceptional circumstance vis-a-vis the general principle of finality in arbitration? Was the court trying to cure any lacuna in the Arbitration Act, or did it risk undermining the fundamental principle on limited court intervention in arbitration? Maybe you can give your explanation to your responses.
Thank you, Commissioner. Yes, indeed, in that case of Mutu, my recollection of reading it is that one of the issues the court had So the court was dealing with about 4 issues. The first one was whether the court can infer existence of an option to appeal when, I think it is section 35, is silent on whether a party who has gone to court for adoption of an award can appeal to the Court of Appeal. And so the question was just very directly whether, in the absence of clarity, in the absence of a direct statement on whether or not there is right of appeal or not, the Supreme Court thought that such an option to appeal could obtain. And reading that judgment, my understanding was that then the court was wrestling with a competition between 2 issues. One is the right of any litigant to a fair hearing, which is a constitutional right, and on the one hand, by the party who wants to appeal. The one party who wants to appeal saying, my rights to fair hearing have been violated, I need an opportunity to ventilate my case. Vis-a-vis the counter-arguments from the other side saying that the policy and intention of arbitration clause is to achieve finality and sooner resolution of disputes. And in some, my understanding of how the Supreme Court arrived at its decision is to balance those 2 rights. One is the right to be heard and right to challenge a situation where the decision of the High Court is so manifestly wrong on its face, vis-a-vis the desired intention of the 2 parties that there should be finality. And as a consequence of balancing those 2 interests, then the Supreme Court said that you will only appeal to the Court of Appeal where you are able to demonstrate that your situation is very distinct. It's not just the usual issues of disaggregation or ordinary displeasure. You have to distinguish a very remarkable dissatisfaction with the way the High Court has dealt with the adoption of the award. And so that's why it is restricted, and that's why, to my mind, it requires leave, because that leave stage is where the court then will sieve legal or factual issue.
So according to it, does not in any way undermine the statutory design of that particular provision?
It doesn't undermine, and it prioritizes fair hearing and justice to all parties.
Okay, I'm satisfied with that response. And number 2, the case of Mitubel Welfare Society. We know the facts, but what the court held is that structural interdict litigation and Article 23(3), sub-Article 3 of the Constitution, particularly when it comes to enforcement of social economic rights such as housing. In this particular matter, the Court of First Instance had issued structural interdicts. The Court of Appeal overturned the decision, saying that structural interdicts were not part of Kenya. So the Supreme Court affirmed that indeed they are applicable in Kenya. However, sometimes this year, there is the Omtata Tribunal's case. I think it was Omtata versus the National Assembly, where the court, in the first instance, issued a structural interdict directing the National Assembly to come up with a tribunal's bill. And that had been given against Parliament, and it held that, in part, proportionate, realistic, and restrained, and that judicial intervention in legislative process is justified only in the clearest of cases. So it appears there are different standards the Supreme Court has given for executive and legislature. So I would want to hear your views on whether we should maintain that the standard for judicial supervision on legislative processes should be higher than that of the executive supervision of executive compliance of court orders? And if so, what is your basis? What is your response, if it's yes or no, and give your explanation?
The Commissioner, so first of all, let me just answer the last limb of your question directly. Yes, I would think that because I would see if it is a question of small claims, it doesn't matter that it is it doesn't matter that it is a matter of small claims. It doesn't matter that the policy for small claims is finality of litigation. What matters is that if there emerges a very significant point that needs consideration by courts, and then it can, I think it could still escalate depending on how it is framed.
Now, Judge, if I get you right for clarity.
Yes.
Do I get it that you maintain that such an issue, even after you are satisfied that is an important question which needs consideration by the SCOC, you will give more credit to the
properly
process.
or not, whether there was public participation, whether it went through all the stages and all that. And so structural interdict would have that inverse effect. It would have the inverse effect of seemingly micromanaging.
And maintain that you can only frog from High Court to the Court of Appeal to the Supreme Court. Will you be looking at the process more than the substance of what? Because that may go contra 159 article.
Okay, first of all, let me just answer your question directly, my lord. That being a letter decision from the Supreme Court, I sometimes wonder whether the less from the case of over 30% gender representation in all government entities, including legislature, where the court had said you must immediately apply the 30% plus, and it has never been achieved up to today. Whether that was I insist you cannot leapfrog. And the reason why it is necessary not to leapfrog is because it needs consideration by the Supreme Court after the other courts have considered it. You can't fly it over to the Supreme Court before the other courts have considered and applied their minds and possibly resolved it.
Yes, so sorry for engaging you. I agree,
yes.
But this is a matter which does not need any clarification, any further clarification. The Supreme Court has already said, if there is an issue of conflicting decisions, that's a matter of GPI. The issue is settled, it's clear. It's just a matter of taking it from the High Court to the Supreme Court and say, this is one of those you say.
Yes, my lord, but I think there are still some cures. For instance, if there are conflicting decisions, and that happened in the issue of statutory notices, they had to set up a special panel right from the High Court to the Court of Appeal before then it go to the Supreme Court. Okay, at that time there was no Supreme Court before it would go to the Court of Appeal. The issue of the other one was the issue of arbitration. So that it is not good enough to just say one High Court judge says this, the other High Court judge
says this, so there is conflicting, let's rush. Or that one bench of the Court of Appeal says this, the other one. I think there is still that aspect of saying, let's now constitute a bench of, say, 5 or 7 judges, either the High Court or the Court of Appeal, to give it a thought before it gets to the Supreme Court. I still insist, my Lord, that even in terms of policy, it would be disadvantageous if somebody just walks to the door of the Supreme Court and says, I have these two decisions, please decide for me, before it escalates. So if you have a bench which has been decided by 333 in Court of Appeal, and you constitute a bench of, say, 7 or 9, the likelihood is that the assembly of that assembly
do you think, Judge,
Yes, ma'am.
that there's a difference between general elections, fresh elections, and a runoff?
General election, fresh elections, and
And a runoff?
runoff.
Yes.
Okay, so runoff would be a situation where nobody garners 50+1 in a presidential election, in which case then the top 2 candidates would go into runoff. General elections is the standard cycle of 5 years elections, and fresh elections is where elections have been nullified and parties have to go back, or rather a constituent entity, either county or constituency, needs to go through another election.
That's very right, Judge. Now, I want us to consider an issue. I believe it has not arisen yet, but it can arise. And let's take a walk to a fresh election. And let's start from a point where a petition challenging a presidential election is filed in the Supreme Court. The position which has been taken by the Supreme Court is that in the event a fresh election is called or ordered, it is only the petitioner and the president-elect who should take part in that fresh election. We are together. So that end, Judge?
Yes.
Yes. Now, let us take it this way. A petition is filed before the Supreme Court challenging the election of a president. And a candidate, an unsuccessful candidate, decides not to file a petition, but with the leave of the Supreme Court, this candidate is allowed to join in these proceedings, in this petition, as an interested party. An interested party has identifiable stake in this matter and has the right to file pleadings.
Yes.
And in these candidates' pleadings, it's stated very, very clearly that I'm in total support of this petition. The election has to be nullified, and once nullified, I am interested to take part in the fresh election. So, the position of this candidate is clear, that I want to take part. He has not acquiesced his or her position in that he has stated very, very clearly in pleadings that if it is the petition succeeds, I also want to run. But the jurisprudence which has been developed as a term is that it is only the president-elect and the petitioner. And the reasoning has been the rest of the candidates, as long as they have not shown any interest, they should not take part, which I agree. But this is a situation whereby this party who has been allowed by the court to come in as an interested party has expressly stated that its intention to run, and eventually the election is nullified and a fresh one called. Will this interested party be able to take part in that fresh election?
Thank you, my lord, for the question. We need to, okay, so your question, as is the nature of always illustrative scenarios, the question doesn't come out as to whether the petitioner is a candidate. But I want to,
the petitioner must be
and it is easier
candidate.
for me to answer the question if you don't, I don't have an answer to that question, because then we would then be looking at it and saying, what if the petitioner was not even a candidate, he's just a public interested litigant, and you are declaring that parties must go back for fresh elections. There has to be other candidates. So I would say in the scenario you've made, the candidates, so long as thank you. Thank you.
Yes, thank you very much. Welcome, and make yourself comfortable.
Thank you.
You have been here not long ago.
Yes, my lady.
Yes, so
Thank
we'll still do a round of introduction for the sake of the record.
Yes, ma'am.
My name is Martha Kome. I'm the chairperson of the Judicial Service Commission, and I welcome you for this interview.
Thank you, my lady.
Good morning.
Good morning.
Name's Isaac Ruto, also Vice Chair.
Thank you.
Good afternoon, my lord. Jacqueline Ngutia, Commissioner, welcome.
Good morning and thank you.
Good afternoon, Justice Katwa. My name is Caroline Lani. You're welcome.
Thank you and good afternoon too.
Good afternoon, Judge. My name is Charity Kisotu, a Commissioner. You are welcome.
Thank you very much.
Good afternoon, Judge. Omwanza Mbati, karibu.
Thank you and good afternoon.
Good afternoon. I'm Joaquin Dongo, representative of the Supreme Court on the Commission.
Thank you.
Good afternoon, Judge.
Good afternoon, my
Anthony Mrima. Welcome, and I wish you the best.
Thank you very much.
Good afternoon, Justice Kigen.
Good afternoon.
Fatuma Sichale, I'm your representative at the Commission. Karibu sana.
Thank you very much.
Good afternoon, Judge.
Good afternoon.
You're welcome. My name is Oluwande Evelyn.
Thank you.
Good afternoon, Judge. Dorcas Odor, Senior Counsel and Attorney General. Welcome.
Yeah, thank you very much, Commissioners. Judge Joseph Kipchumba Kigen Katwa.
Yes, my
Could you
lady.
tell us your county and your ethnicity?
My county is Elgeyo Marakwet and my ethnicity is Keyo.
Very well. Do you know why we ask that intrusive question?
I do, my lady.
Why?
I think for regional balancing and, yeah, basically regional balancing, I think.
Is it a constitutional imperative?
Yes.
Which particular article?
I can't quite place my finger on the exact article, but I would say it is intended by Article 10, Article 7283, and Article 236.
Yes, very well. So now we will start. You were here not long ago, and I think the challenges I have is what questions to ask you, because we recently interviewed you successfully for the judge of the Court of Appeal, and you have hardly been there for 3 months. You under normal human HR practice, human resource practice, at least one stays in a job for 6 months to be evaluated for promotion. You haven't been there for even 6 months for promotion. So maybe you can explain this before we go to the questions.
Yes, my lady. I know that you very particularly mentioned the point that I haven't been there for more than 3 months, and that in an ideal environment I should have waited for a little more time so that there is perimeters for my evaluation for promotion. My lady and commissioners, my understanding of why I am here is different from that. My understanding is that I've come here for evaluation as to whether or not I'm eligible for appointment to the Supreme Court, and that eligibility is not a question of promotion, it's a question of whether I'm qualified. And when I looked at the scoping that was done for a person who can qualify for that office, I thought I met the conditions, and in the circumstances I applied. So, Chair and Commissioners, I'm here very humbly seeking that I be evaluated on my competence to be appointed. And the fact that I may have recently been before you should not be a factor, because I'm not here for a promotion. I'm here for whether I'm competent. I also observed that quite a number of people have come to the Supreme Court directly from outside judiciary. And so judiciary is not necessarily a stepping stone for qualification to qualify for that office. Those are the considerations that were in my mind, Chair and Commissioners. And I say this with the greatest humility.
Mm-hmm. Very well. Now, then we can come back and forth to that question of, are you happy in the Court of Appeal? Are you satisfied with being a judge in the Court of Appeal?
I am, my lady and commissioners, and thank you very much for having found me deserving to take up that office. I want to express my gratitude to all of you.
Mm-hmm.
Yes.
Yes. So now, we want to hear from you why you think this commission should recommend you for nomination of the office of a judge of the Supreme Court. We want to hear what experiences and skills and knowledge you will bring to this court, and how you're going to leverage them or to locate these skills within the 5 or so jurisdictions of the Supreme Court.
Thank you, Chair and Commissioners. I consider myself eligible for consideration to the office of Supreme Court Judge on the premises that, in my estimation, I have a feel and experience of all facets of Kenyan, both as a Kenyan citizen and also my competence in legal practice. I grew up in an environment where, in an environment of want, I went to Kiplombe Primary School, I went to Mother of Apostles Seminary, I then went to St. Patrick's High School, then came to Nairobi University, and through all those levels, it was hard work, enterprise, and studies that took me through all that. I then entered into legal profession now for about 30 years. And I have both national and international experiences. I have represented all cadres of people. I have gone to all legal forums and even non-legal forums. And the wealth of all those experiences, my lady and commissioners, are such that I would contend that makes me very qualified for this. A little more on the issues of where I've appeared. I appeared in tribunals, I appeared before commissions, I appeared before magistrates all the way to the Supreme Court. I have represented judges, I have represented advocates, I have represented other people. I mentioned particularly representing advocates and judges just to make the point that those are the best judges of my competence, and if in their evaluation they thought I could represent them, then it is a strong statement of my competence. I think the type of works I have done, the results I have produced, are such that they also strongly comment on my competence. I will not pretend to know all the law, both in terms of statutes or precedents. I will not pretend. But what I can say for a fact is that I have the competence to identify what the issues are, to be able to analyze them, to be able to research and familiarize myself with what I need to determine. And this is born out of experience. I have represented people outside the country where I've had to learn other legal regimes and systems, and particularly the confluence of common law and civil law at the ICC. I have had to study and analyze the operations of sports law and represented athletes on sports law. And the legal regime, I appeared even long before the legal statutes were quite in place in Kenya. And so there was near vacuum on what we need to look out for. And it was through my research and enterprise that I was able to familiarize myself and be able to represent them. I have also appeared in the East African Court in Arusha, and that required of me to look beyond the statutes that apply in Kenya, to look at the statutes that apply in East Africa and internationally. And the accumulation of all those experiences, my lady and commissioners, are such that I contend that I'm in a position to be of service to the judiciary at the level of the Supreme Court.
Thank you very much. We will now move on to another area, and Justice Ishale will take it from here.
Thank you, Honorable Chief Justice. Judge Kigen, there are concerns expressed by a section of Kenyans.
Yes.
As regards your suitability for the position of a Supreme Court judge.
Yes.
And these concerns were made known to us as the Judicial Service Commission via a letter dated 8th of April 2026, which we have since brought it to your attention. Did you get that letter?
No.
Oh, I'm sorry.
No, I'm hearing it for the first time. But I suspect I know what it could say. Probably just say it.
Okay. Let me just bring to your attention what the section of Kenyans are saying. They're expressing their misgivings about your candidature. Firstly, they are concerned over the fact that you've been a lawyer for His Excellency President William Ruto, and who is likely to be a candidate in the elections of 2027. The fear that these Kenyans have is that in the event that you are successful and you join the 6 judges in the Supreme Court, and then thereafter there is a petition challenging presidential elections for the year 2027, their fear is that you are likely not to be impartial. What do you have to say to this?
Okay, so first of all, it is true I have represented him. May I say that I intend to be as objective and neutral in my discharge of my functions as a judge. And so the fear is, well, I can't say it is ill-informed. I can understand the concerns, but I just want to give the assurance that I would be fair and I would only deal with facts and the law. I would also like to say 2 other things, commissioners. The first one is I am aware that that concern has been, and that's why I was saying I have suspicions that of what the letter is, and I must complain that you didn't share the letter with me so that I would have a more structured answer to the question. But let me just answer to this effect. That I have looked at the totality of judges, right from the High Court, Court of Appeal to Supreme Court. Looking at the totality of them, you would almost say about 50% of them were lawyers. And so for me to be told that you have a disadvantage because you represented a particular individual would be a borderline case of discrimination, because I would be being treated differently just because of the type of the client I represented, when in fact every other person who escalated to the status of a judge who was an advocate is not being subjected to the same disadvantage. And so, commissioners, with a lot of humility, I would pray that first of all, you look at me for what I stand for, integrity, fairness, and justice, and that I will apply the law fairly and objectively. But secondly, that to distinguish me just because of one client, a criteria that has not been applied to other candidates who applied to be judges, would probably not be quite fair. And lastly is that there are measures, if anybody is concerned about my sitting in the bench and as justifiable cause, there are provisions for how that can be handled, including recusal, and I'm aware that some presidential petitions have been done with less than the totality of the 7 Supreme Court judges. And the Supreme Court's workload is not focused or limited to only presidential petitions. There are other work assignments that the Supreme Court has. And so if it were to be such a significant and weighty concern, I would say there is that option also for recusal. For all those reasons, commissioners, I pray that that should not be used to my disadvantage in this interview. I am glad to answer any specific issues that arise around that issue.
All right. I think we hear what you are saying.
Yes.
But you know, when it comes to the dispensation of justice, it is not important. It's not only important for justice to be done, but justice must also be seen to be done. And given the fact of the office in question, the stakes are extremely very high. And when you tell us, for instance, that there is that possibility that you can recuse yourself, and given that the number is only 7, and you know there are many things that happen in life, people fall sick, etc., etc. So if now we are saying we are going to take you, and then you've given us that undertaking that in the event that there is an objection to your hearing an election petition, presidential election petition, there is that possibility that you can recuse yourself. So what does that mean? That then, do we really even need to hire a 7th judge for the court? If we have the option of a recusal, right from the word go.
Can I proceed?
Pardon?
I can answer now.
Yes, please.
Okay. So, recusal is probably the bottom in the list, my lady. I would insist that I should be taken for what I say and what I have represented, being objective. My relationship with His Excellency is not such that I always said yes to everything he wanted or he wished for. And so it has never taken my objectivity away. But I understand your question to be more of the perception of third parties. So again, I want to say that the front line is to say that I should be taken for what I represent, that I intend to be objective and fair, and that issue of recusal should be the last option. And even as I'm being put to task to answer that, I also want to insist that please take on board also the unfairness of the question and the unfairness of the concern just because of the person that I represented, a criteria that is not applied to other candidates.
All right. We just thought that it was important to bring to your attention what a section of the Kenyans are saying about your candidature.
I understand.
And you've given us your responses.
Yes.
The other concern, of course, was the fact that you've hardly been in the Court of Appeal, but I think you've discussed that in response to what the Chief Justice asked you. So now to my technical question. In a book entitled Cases That Changed Our Lives by one Ian McDougall, and in a scholarly article in that book, the scholar marvels at the wonders of the law, and I want to quote what he says: "Who would have ever thought that a partially decomposed snail in a ginger beer bottle would change the course of English legal history?" I'm sure you're aware of this case. A snail in a ginger beer bottle.
It doesn't come to mind immediately, my lady.
Wow. Because then my next question was going to be, yes, how did this case change the course of legal history in the countries that practice common law? Don't know you versus Stevenson?
Oh yeah, of course I know you versus Stevenson.
Yes. What was the law before the snail?
I know the law that was developed in that case being that whoever keeps an item that causes damage to injury to somebody else is responsible for the damage that follows.
I asked the question, what was the law before the snail? Keeping in mind the doctrine of the privity of contract. And if I may just remind you about the facts of that case, is that two ladies went to a cafe. One bought the 2 drinks, but Mrs. Donoghue was not the one who paid for the drink, and a snail was discovered in the bottle. And then the big question was, could she sue, and yet there was no privity of contract? She's not the one who had purchased the ginger ale. Are we together?
Yes.
Yes. So what was the law before then, and what is the law now?
My understanding of, okay, I can't say for a fact I know what the law was previously, but I suppose considering what the law then developed in that case must have been that it is a condition for you to claim damages that there is a privity of contract that you have to have.
You're supposed to do the same without fear, favor, or any kind of pressure or direction. Now, in your view, are there any safeguards against interference with the independence of judges in the current framework that we have? If you have any, you can mention them. And the second limb of my question, where then is the balance between measuring performance and safeguards, if there are any?
the only argument I would make around that issue is I have no doubt in my mind that there is need to measure performance, and there is need to require the judiciary to demonstrate that they have delivered on it. I have no doubt about that. I think it's the question of how you balance the intricacies around it. And I would think the conversation should be more in saying, are the targets placed on the judges and magistrates too onerous to a point where, in consequence, they look more at making determination even where quality could be sacrificed so that you meet targets. So I think the conversation should be more whether the targets have been balanced in a way that it doesn't place pressure to a point of diminishing the quality of the work done. I would think the conversation would be more there than whether or not there is need for performance. And that's where the balance, I think, needs to be placed.
Okay, that's where the balance, but do we have any safeguards in our laws, maybe statutory?
Yes.
Or even constitutional?
Yes.
To protect or to safeguard the independence of the individual judges and judicial officers vis-a-vis measuring their performance?
Yes, the general proposition that they have judicial independence, I think, is, and the fact that judicial independence right is protected in itself, I think, is the countermeasure to ensure that. And then probably a little more on the judges, also the security of tenure, the process of recruitment, and the budget arrangement for the judiciary. All those, I think, give some level of cushion to protect the judicial officers and the judges.
Okay. Thank you, and I wish you well.
Thank you very much.
Thank you, Honorable Chair. Honorable Judge, I know you've been on that seat for too long, yes, but don't worry, we're about to finish, so my session will not take too long. And now, please address us on the tension between judicial independence and judicial accountability, and tell us how the tension is managed at the level of the Supreme Court, where there is no higher court or where there is no further appeal.
Judicial independence and judicial accountability, I think, is probably the conversation we've just had with the previous interviewer, being the need to arrange so that the judiciary is not such that it is a castle, it is a lord unto itself, but is accountable to the public. And so, to my mind, it's a question of just balancing that in the quest to ensure that there is delivery of services, pressure is not placed to a point where the quality of work is diminished. But that independence is necessary and accountability is necessary. And to the extent that your question is, the tension is that my view is that they have to coexist. So somehow they have to find a balance, because both of them are necessary to be to the taxpayers. In terms of the Supreme Court, I think the quality of the work done, I should imagine also that they also have policies on targets of what they are supposed to achieve in terms of timelines and things like that. And I think that still takes care of any concerns that they are not accountable to anybody. But importantly, I think they are accountable in terms of the need to present the state of the judiciary, the need to make presentations to Parliament, the need to justify budgets, and also the public, the access of the public to see their performance is a countermeasure that ensures that the Supreme Court delivers on its mandate reasonably, within time, and to the quality.
Okay. How has the Constitution provided for the independence of the judiciary?
So the independence of the judiciary in the Constitution would include issues like what we are going through, the procedure for recruiting judges, that it is open and public, and the evaluation of the competencies is merit-based. There is security of tenure. There is separation of the budget for the judiciary. Those ones come to mind immediately.
Okay, thank you. I'm satisfied. I'm satisfied with those.
Thank you.
The final question from me, I have looked at your choice of referees.
Yes.
You're positively and highly recommended by the referees you provided. And indeed, I can say you know people. So now, given this as a judge of the Supreme Court, if you are to receive a phone call or a message from a senior state officer in regards to a matter that is before the court, how would you go about that situation?
Okay, I would do what the law requires me to do. I would apply the law to the facts, and it doesn't matter what message or call I have received. I would remain faithful to my calling and to my oath of office.
Would you honor that engagement?
No.
Or discussion?
No, I wouldn't.
Okay. Thank you, and I wish you well, Judge.
Thank you too.
Thank you, Honorable Chair, and welcome again, Judge.
Yes.
Yeah, I have two questions for you. Very, very brief. Now, the judiciary is increasingly adapting digital systems such as e-filing, virtual hearings, and automated case management platforms. While these reforms promise efficiency gains, they also raise concerns about digital exclusion, cybersecurity risk, and over-reliance on technology vendors. How should the Supreme Court guide the judiciary in balancing technological modernization with constitutional guarantees of access to justice and data protection, especially for vulnerable and digitally marginalized groups?
Okay, so thank you. I think it's a question of continuously being diligently conscious of the environment we are in, and always looking out to make sure that some segment of the population is not left out. And in that regard, I think the concept contained in the statute is a very useful one, because it endeavors to reach those ones whose access to technology and whose geographical locations may be so far flung off to a point where they might be excluded from the judicial process. So I would think that the Supreme Court, where occasion arises, would also encourage those that kind of enterprise containing the statute, the ADR and the AGS. On the technology, on cybercrime, I think it is also a question of diligence, remaining very vigilant to make sure that the technology deployed are up to date to a point where it doesn't expose the judicial functioning to the risk of cybercrime and hijacking and frustration.
Okay. Yes. Now, in circumstances where a constitutionally sound decision is likely to be unpopular and could create or trigger a political backlash, how would you uphold integrity, impartiality, while maintaining the court institutional legitimacy?
Okay, I understand the question, Commissioner, to be what I would do if there is what did
there's a case before you.
Yes.
And the decision would actually trigger a political backlash. So how would you maintain or even uphold integrity while maintaining the court institutional legitimacy? The decision might likely
I
be
got the question.
unpopular.
Yes. You could even replace that by saying